Good morning, everyone, and welcome to this webinar here where we are going to discuss what exactly is the kind of work that capital market teams of law firms do. So, we to discuss this topic, we have with us Chaitanya, and Chaitanya is an alumnus of GNLU. He has had a stint as a senior associate with Cyril Amarchand, Mangaldas, where he was with their capital markets team. And I have worked with Chaitanya before, like I have had some insights from him. His concepts in relation to, how IPOs process works are brilliant. So we are going to have him deliberate on this topic. And Chaitanya, why don't you share a little bit about your journey with us?
Thank you for the introduction, Komal. Just for the record, I was not a senior associate, but I was an associate with CAM for 3 years, and
Okay.
thank you for giving me this opportunity to explain what capital market lawyers do. What do they what should the freshers expect from the law firms? So yeah, thank you for the introduction, Komal. It's been good working with you guys till now, and you have a good online platform which is very helpful for the new and upcoming lawyers, be it in a different field. Thank you. Yeah, let's
Okay,
go ahead.
great, great, great. So, just to begin with, and to break the ice on the topic, the first thing is how many firms or who are these firms who actually have capital markets related practices? Do we have many firms? Is it only the top tier firms who have the capital market practices? How does that work? Like, how many
So
firms have this?
almost all tier one for sure. Mostly tier two and tier three law firms also have their capital markets team. Uh, it might be ad hoc, but they do have law firms like Juriscorp, Vadia Gandhi, DSK Legal. They do have their capital markets team. I've been seeing other small law firms also taking a part in certain SME IPOs. So I recommend if it's tier two, tier three, which you're aiming for, you should always ask the law firm if they do have a capital markets team. Then surely you can think about venturing into that particular scope.
And does it need, like, does it have to be a huge team, given the kind of work, or how do you find that? Like,
See, there are two ways to it. One is the exposure which you want. Obviously, tier two and tier three law firms, there is more work with less people. So your groundwork, your execution will be your exposure will be much larger as compared to tier one law firms. So that is one thing to look at. The other thing is the name you want. If you work with tier one law firms, there will be comparatively less work. I won't say there's absolutely less work, but there will be comparatively less work. The responsibility will be very much given to you that this is what your responsibility is, and you'll get the fame of a tier one tag, and the clients are also that huge. The public issues or the private placings which are done by the top tier law firms will be way creamier, I would say, than tier two, tier three. But the exposure would be higher in tier two, tier three.
right, right, right. Yeah. And like, which would be the ones that are typically known for, a capital markets practice? Let's say the capital markets practice is dominant in this firm.
So
Are there
my
any?
yeah yeah.
Or,
So my personal favorite is obviously Cyril and Mangaldas. It has an excellent team, very well organized team. Cam has same stands for the other brother, which is Shah Mangaldas. It also has a very good team, very organized. The other one, which is very prominent in the capital market sphere, is SNR Associates, which is doing a good job. Apart from also Indus Law, which is now Manan Lahoti was a Luthra partner, and he took the whole team and joined Indus Law. So Indus Law would also be a great team. I've worked with Manan's team a lot of times, and I feel they're really well organized and professional. Trilegal is also great, and Khaitan is known for doing good work. So by volume, by clientele, it's Cam always. But by the number of deals and the number of transactions, I think it's Khaitan or AZB.
great. Okay, so let's come right back on to the topic of the webinar is in what is a kind of work, what exactly do you get to do when you enter into a capital markets team? If you can take, let's suppose uh, someone is joining the team as a real fresher.
Okay.
Okay,
Okay.
so A1 level. So what will this kind of person get to? What's the kind of work that these teams have?
So, to start with, the major chunk of work which is given to a fresher, that's an A0, like the first year of an associate, in capital markets would be diligence. But it honestly depends on your luck. For example, when did you join? So if you are joining and you have been added to a transaction which is in the middle of a big IPO, then you'll be given to do more other kinds of work than diligence itself. But expect yourself doing 95% of the work as a diligence work. Diligence would be the major part of work which you will be doing. Other work is that if you're lucky, you will be, say, starting a transaction, say IPO. There are certain, items which are done before the diligence starts, like creating a checklist, preparing a publicity guideline, preparing a kickoff meeting. Those are the work which you will be doing at the instance at the first, but you will end up doing diligence at the end. So diligence would be a major part, I would say.
Right, right. And is this only related to, let's say, an IPO or a public issue? Is there any other work other that doesn't fall within the sphere of a public issue, which you will get a
No, so public issue would be IPO, but you can expect doing QUIPs, which is a private placement. You
ah
can also end up doing debt issuance like NCD issuances or bond issuances,
yes,
which are happening.
exactly.
So it's either debt capital markets or equity capital markets. But QUIP is an issuance, a qualified institutional placement done by a listed company. So then you'll have to go through the corporate actions which they have done during the past 3 years or 5 years maybe. So if you're assigned to a QUIP, then you should expect vetting the company properly from the BSE or NSE website. That's an additional work which you'll have to do because it's a public listed company and the information is usually provided. So
Yeah. Uh, and I have a sub question to this, which you raised the issue of QUIP, which is a qualified institutional placement. Do companies debut with a QUIP? Like, because the guidelines do say that when you don't fulfill the eligibility criteria, you can actually go ahead with a QUIP. Like you can debut or you can have your IPO with a QUIP.
no,
Have you seen?
no,
Uh,
it's not possible for a person, sorry, an unlisted company to debut with a QUIP. Either it's a deemed listed company, or it's a public. It had done an IPO before, because a QUIP is a qualified institutional placement undertaken by a listed entity. So I haven't come across any such situation where somebody's debuting with QUIP. It's a further issuance, I must say, but it's not but an unlisted company can do a private placement, which is different than a QUIP under the
No,
company
I
law.
mean private placement is definitely where you are not hitting the public markets.
Yeah.
But I think there are ICDR provisions which say that if you do not meet the eligibility criteria for your public issue, you can actually go to the extent of 75% of a qualified institutional placement, and the remaining 20% will be by a book building, 25% will be by a book building,
So
and you
that
can
is, you're talking about regulation 6.2? Yeah,
ICDR
of the ICDR,
issue.
regulation 6.2 of the
So
ICDR.
I think I don't have the number right now, but it is the one dealing with eligibility criteria
Okay,
as
no, so
such.
that eligibility criteria is two ways. One is usually 65. So the proportion for an IPO is 65% is for QIBs, qualified institutional buyers, QIBs, and then the remaining is for retail HNIs, and the reservation portion is up to 5%, and the remaining 30% or 35%, whatever the case is, for retail and HNIs. That is one in certain criterias, eligibility criterias. If you fall under this particular regulation, then you can allot your shares. 60% should be allotted to QIBs. And in other criteria, you can allot it to 70% quip. So I think it is from a public issue perspective, but I'm sure we can check it out later and I can get back to you personally on this particular situation.
Yeah, sure. But we are not getting into the details of that. It
Yeah.
was just a sub question that that kind of came up
Okay.
with the discussion on Quip. Then we have someone else asking, wouldn't the debt securities be dealt with by the banking team? But here we are talking about a debt listing,
Yeah. So
Mittal.
it's about debt issuance. So
Yeah.
every issuance will have a lawyer. Every issuance will have bankers to the deal. There are book running lead managers which are for public issuances, and then there are bankers for debt issuances like I think Altico Capital. I don't remember the name, but every deal, every issuance will have a banker. Every issuance will have a set of lawyers, and we are the lawyers.
Of course. Even private placements for that matter, even
Yeah,
in
yeah,
unlisted entities, even still you will have it, right?
yeah. Correct,
So,
correct, correct.
yeah, people, I don't know why people are facing disturbance. I think I can hear things clearly. So, okay, there are other questions here which are talking about what should a fresher prepare, and this was one of the questions that came. But let's come into the core part of the work, and we'll come to the career aspects a little bit later part. So, the if you're looking at the core aspects of work, due diligence, what exactly do you get to do? Like preparing requisition lists, gathering information,
Yeah.
reviewing. Do you actually get to work on a due diligence report, or that comes at a very later stage, like
So,
the preparation?
from an IPO angle or from a quip angle, any issuance angle,
Yeah,
a capital markets lawyer, he might be a lucky lawyer because he doesn't prepare diligence reports.
yeah.
Whatever
It's
he's
just
working
a
on
yeah,
is the offer document. It
yeah,
has different
yeah,
names like DRHP, RHP, prospectus,
yeah.
PPD, placement document. Different issuances have different nomenclatures, but let's call it offer document in general. So the diligence which is done by a person as a fresher, I would be very honest, is you won't be allowed to handle or given complete responsibility of the whole document. There are different chapters. A DRHP, if you look at a SEBI's website, you can there are a lot of DRHPs publicly available. It has, if you look at a table of content, there are so many sections to it. Now, the diligence heavy sections are litigation, approvals, capital structure of the company, history, and certain other corporate matters. The business sections, which is risk factors, our business, MD&A, and industry overview. So, in the diligence heavy chapters would be, I would say, it's litigation, material approvals of the company, the capital structure, because capital structure involves the minutes meeting. So whatever board meetings, shareholders meetings, other committee meetings which have been done by the company during these last 3 years or 5 years, as the case may be, will have to be diligenced by a lawyer. So that is the heavy work you'll be given. Your seniors would be the person responsible for the chapters, but you'll be given small assignments under it. One can be given to do minutes diligence. One can be given to summarize litigations of the company with the threshold as decided between the deal teams, and one would be given to summarize the approvals. Now, approvals is a huge chunk. Litigation is a huge chunk. It depends on the company or the issuer which is going for the IPO or the QIP. It might be a company which is facing a lot of litigation battles, and you'll have to end up a lot of summarizing a lot of tax matters or any other criminal civil litigations. Approvals also, if it's a real estate company, then it would be fun for you in the wrong way because you will have all approvals to take care of, from OCs to lift
Yeah,
approvals to anything
yeah,
under the
yeah,
sun.
yeah, yeah. So I have a lot of questions here, I think, which deal mainly with a process. So can you just, take us through a little bit of how the lawyers are involved at each touch point? So where exactly do you start from your engagement, and then how do the activities go right up to the point where you are actually, getting the people to subscribe to the shares? From a
Okay,
lawyer's
so
perspective, what are the few steps? If you could just
so
summarize
I
it.
I will I'll start from the scratch. your law firms would get a call from the bankers or the issuer, the proposed issuer, that we are undertaking to undertake. We're thinking of going for an IPO. We would want you to appoint you to be appointed as the lawyers to the company or the lawyers to the bankers. There are two lawyers in every deal. There are three lawyers. If it is an international deal, then there will be international legal counsels to the banker as well. If it's a local domestic deal, of course, there are nomenclatures to it, but there will be a legal counsels to the bankers and a legal counsel to the company. Or in certain such situations, only one lawyer, only one legal counsel will be appointed for all the deal teams. That's also the case. So basically, you'll go to a meeting where there will be a meeting with the management of the company, the main heads of different departments of the company, say accounting, secretarial, legal, approval, everybody would be there. The top guys of the main bosses of the bankers would also be there, and your main partner or your senior managing partner or equity partner would be there as well. And that is called a kickoff meeting. A kickoff meeting is basically a presentation given by the bankers that this is the timeline, this is what we're expecting from the deal, and we would want to do, these are the tentative timelines of an IPO. So once you take note of it, you will technically go back to your different separate offices, and the councils, the legal councils will have to prepare something known as a diligence checklist. Now, this checklist is an exhaustive list of all the documents which a law firm would require to carry out reasonable due diligence for the IPO. So it will include everything under the sun. Chapter-wise organization would be there, and you will have precedents. All law firms have precedents of diligence checklist. You just have to take up, ensure that the sector which the company belongs to, the main points, like if it's a real estate company, you need to ask questions about RERA. If it's an insurance company, you need to ask questions about IRDA, IRDAI, or any research reports or something. So you have to be very specific which sector the company belongs to. You can add up your own checklist and you can send it to the company, of course, vetted by the other legal counsel as well. That is the first step. Once you send that out, that usually takes 1 to 2 hours for a fresher, and then 15 minutes for an experienced guy. Once you do that, you will have to, the senior will also tell you to work on something which is known as publicity guidelines. Now, publicity guidelines is the Bible of publicity restrictions applicable to all the deal teams to this transaction. I mean, it would be applicable to the banker, its affiliates. It will be applicable to the company, its affiliates, its subsidiaries, its affiliates would include everything technically. So publicity guidelines is how do you talk about IPO, and what would you talk about IPO in terms of SEBI ICDR regulations, in terms of the SEBI Act, in terms of trading regulations, and all kinds of regulations. So that is a publicity guidelines which will be shared by the international council. If there is one international legal counsel appointed, he will be sharing, or he or she will be sharing the international publicity guidelines towards the company, and we as a domestic legal counsels will add up our domestic publicity guidelines, and we'll send it to the company saying this is, you have to adhere to this, these are the do's and don'ts. That is the next step. Next would be technically you will have a few days to chill, because the checklist has to be replied by the company. And if it's a very professional company and it's a big transaction, you expect them to upload all the documents or give you all the documents at the right time. And they will upload all the documents on the virtual data room, or they'll tell you to come physically vet it. Certain items like reports or board meetings or shareholders meeting would not be shared online, and certain items like criminal litigation, where they're lump sum, you'll have to go and physically diligence it at their office. So you can, you'll end up planning a time with the other lawyer, and you'll go there and diligence all the documents physically. So the company will start uploading documents on the VDR. That is the next step, and then the work will start. So meanwhile, while the company is uploading documents on the VDR, what the seniors to your seniors, the senior lawyers would do is they would strategize on how to go about with the offer document. The first step is drafting of the offer document. they'll have multiple tables of contents, and everything. They will have precedents for of DRHPs, and it's usually they have a set precedent, set language, set format. Format, of course, is according to ICDR, which is Times New Roman 11. So format would be the same. So there would be a set of DRHPs available, and you will start vetting the existing DRHP, like redacting the previous deal and basically blobbing all the previous information and preparing what we say khoka. It's a template, and you will keep it ready. And as soon as the information comes on the VDR, you'll start diligencing. Of course, you'll be given your task according to your seniors. One would handle litigation, one would handle capital structure. But you don't have to worry. You'll be given ample training to do all these things, because you, as a fresher, would have no idea on how to go about it. So there would be somebody who would be guiding you. So not to worry about it. So once you get the preliminary reply to the diligence checklist which you shared, the next steps would be you keep on revetting the responses, reviewing the documents uploaded on the VDR, and whatever answers you've got, whatever diligence you have done, if you have follow-up questions, you need to ask to the company, right? So that is the first requisitions list which will be shared with the company. Requisition list is just sounds fancy, but it's just asking questions on the diligence based questions which you have, or to the questions which were not responded by the company in your checklist. So you'll create a requisitions list, a complete requisitions list, which will be shared to the company. Now, I would suggest you to do it category wise, because companies usually have a different department for accounts, for secretarial, for litigation, for approvals. So if you create a subheading of say litigation and put in all your litigation questions under that subheading, they can simply extract that and send it to their respective department. It ensures efficiency and
Absolutely. Yeah.
organization from a law firm's point of view, and it will give you brownie points with your immediate senior as well. They'll like it. And you can that is the first requisition list, and then you keep on building on the document, the DRHP, the offer document. You keep on filling in the missing points. And meanwhile, while you're doing it, there are two important things, because it's a company, it's a private company, or if it's a if it's a public listed deemed public company, then it's fine. But if it's a private company, then you'll have to change your articles of association according to the requirements of the standard AOA format from the Companies Act as well. So that is one extra work which you'll have to do. You'll have to vet their existing AOA and MOA, and then accordingly modify it and keep it in line with the listing obligations and disclosure requirement. Because as soon as the company lists, it has to be, it will be governed under the LODR, which is the listing obligations disclosure requirement regulations, SEBI LODR regulations. So vetting has to be done from an LODR angle as well. Now, when I'm talking about LODR angle, there are a few points. One is there are certain committees which have to be constituted. These committees are in according to the LODR regulations as well. You'll have to constitute it, and there are certain policies. There are policies which have to be adhered to, which have to be approved by the board, which are required for a listed company to have. Like simple policies would be uh, corporate governance policy. There are a list of policies. Don't worry, even your law firms will have a bunch of it ready. There are lacks of precedents for policies. It's a set format which is being used consistently, and of course being updated as the law is getting updated. So you'll have a bunch of draft policies which you'll have to share with the company. Now you'll have to be very cautious here. Now the policies have to be approved by the company. So it is the company's work, and the other parts of the deal teams wouldn't care about it. So it is the legal counsel of the company. The legal counsel of the company is responsibility to send the policies to the company and coordinate with the concerned department and get it approved. The other lawyers won't be involved. It's between the company and their counsel. The next would be board resolutions, which will be done during this DRHP stage. Now, there are certain resolutions to be approved by the board members or the shareholders during this IPO process, at the DRHP stage, at the RSP stage, at the prospectus stage. So we have a format of all resolutions available with the law firms. These are set resolutions which have to be passed by the company during the DRHP stage. So the formats, the drafts of these board resolutions, shareholder resolutions have to be shared by the company. This will be vetted by the other legal counsel as well. So you'll internally share it, and then as your company's counsel, you'll be sharing it with the issuer company. So that is done. Next is the auditor's deliverables. The legal counsels to the bankers have to worry about this, because auditors to the company, they will be opining on something, and you would require, as a banker, you would require certain certificates from them as a comfort letter. So there is a comfort letter, there is an arrangement letter, there are certain certificates like KPI certificate. I won't get into the technicalities, but auditor deliverables are on the head of the legal counsels to the bankers, and they have to take care of it. Of course, they will have a set standard, not to worry about it. So once all these things are sorted, you will keep on vetting the document. You'll keep on filling up all the chapters of the DRHP, the offer document. And please keep in mind, Schedule 6 has to be very strictly adhered to. Those are the disclosure requirements under the DRHP, and you'll have to adhere that everything has been taken care of. All the disclosures are in according to the schedule. Uh, if there's a question that what happens if schedule 6 is not adhered to, is that every banker has to give a due diligence certificate that everything has been due diligenced properly. So if the banker is taking a responsibility on their letterhead, then they won't let you go ahead if everything is done, taken care of properly. And even the legal counsels of the bank will ensure that their clients are happy. So schedule 6 should be followed very properly, strictly adhered to. Once it is done, and your DRHP is sort of complete from end to end, you'll expect sign-offs from all the deal teams. Being a company's counsel, you are the legal counsels to the company are the guys who are preparing the document, the offer document. The legal counsels to the bankers, they will only vet it. They will comment on it. They won't draft anything. The drafting counsels on this deal are the domestic legal counsels to the company, or for business sections, the drafting counsels will be the international legal counsels. If there's only it's a domestic deal, then the domestic legal counsels to the company will be the drafting counsels for business sections as well. That's a lot of work, but I think it would be a rich mandate as well. So that is one where you will be the person responsible for drafting it. So once everybody has vetted it and everybody has signed off, the bankers on their letterhead would be filing the document with SEBI and national stock exchanges. The NSE and the BSE, the designated stock exchanges. There are two designated stock exchanges. One is NSE and the other one is BSE, and of course with SEBI. Now they have to submit a diligence certificate. There's a certain checklist to be followed while you're submitting the DRHP. That checklist that's an ICDR checklist, would be drafted by the bankers council, because again it's very logical. It's an ICDR checklist. Basically, every regulation is pasted in a table which is applicable to an IPO or a QIP. Every regulation will be copy pasted in a tabular format, and the bankers will have to reply saying, yeah, it has been complied to, yeah, it has been complied to, or whatever the case may be. So of course, being banker submitting it, the bankers council will be vetting it and will be drafting it. That point of time, the company's council will be commenting on it. So that is one point where it's the other way around. Otherwise, it's the company's council which usually does all the drafting of the offer document. So once the DRHP is filed, within 28 days, the SEBI would have to have to provide its observation on the DRHP. Now, 28 days is a tricky question. Sometimes, you'll keep on receiving observations. You'll keep on receiving observations from NSE and BSE as well. So 28 days. So if you receive an observation from NSE, the 28 days will be applicable in a different manner. But let's keep it simple. Let's not make it complex. Say April 1, you have filed the DRHP. By April 29th, you should expect SEBI's observations. It's a list of observations. Observations are basically questions telling you to do this, do that, and change your modified DRHP according to what they think is required. Now, these observations are very, very specific. They can be a bit general, and they usually come. These are questions raised by SEBI on the chapters of the DRHP. So, again, not getting into the complexities of these observations, I'll keep it simple that these observations are usually saying that you have to modify this, or where is this, or is this fine, and then you'll have to modify the DRHP accordingly. Now you will receive observations. You may not, or may receive observations from NSE and BSE before you get an in principle approval from these designated stock exchanges for the process. You'll have to adhere to that. You have to reply to these designated stock exchanges questions, observations as well, and sort them out as well on time. So once, say, you have received observations and you have replied positively, and SEBI has gotten back saying that okay, we are okay with your modifications, you will modify your DRHP. You'll update your DRHP. And what is the next step for updating is that it's known as updated draft red herring prospectus. It's an updated offer document, which you'll be resubmitting it to SEBI with a red line or a black line, a comparison of the DRHP which you had filed with SEBI, saying that these are the changes. You can see it in red line in the comparison, and we as per your suggested modifications, we have done these changes. Please approve our UDRHP, updated offer document. Then so we can go ahead with the further issuance. So SEBI would within a week, I think, come back. Usually there's no timeline for it, so it might take time, or they might have further questions. So, but within a week, it might come back saying, okay, we are okay with it. Please ensure that everything is taken care of, and you can file the red herring prospectus, the second part, with the ROC. Now, technically, after the DRHP, UDRHP is approved by SEBI, you don't have to file the RHP with SEBI for approval purposes. You'll have to file it with SEBI for within some stipulated, I think 30 days or something. You'll have to file it with SEBI, but the next step is with the ROC, the regional ROC. So if it's
So
an
that
under
filing again is with the lawyer, so then it's with the company, with the
which
ROC.
no, so with which filing are you talking about?
Just the final RHP with the ROC.
Yeah, no,
That's
no.
also a part of, or
Yeah, yeah,
it's
yeah.
it's the company's role.
Yeah. It's the company's rule. So basically, whatever changes you have suggested, you update that to the DRHP. You change draft red herring prospectus to red herring prospectus across the DRHP, and then you file the RHP with ROC. Throughout the deal, till the listing is done, the lawyers will be involved. So it is the company's counsel. So who company's legal counsel will be vetting it and will be drafting it. So it's all company. So after the RHP is filed with the ROC, maybe within a day or two, you will receive an approval from the ROC saying that you can go ahead with an IPO. That time, it is the question would be that as soon as you file the RHP with ROC, and as soon as you get the approval from ROC, you'll have to go ahead with the issuance. So that is a crucial time where once you get an approval from SEBI on the draft offer document and your offer document is sort of ready, you will discuss with the bankers, with the deal teams, with the company, saying that okay, if everything is fine, is market good to go ahead? Will we get enough subscriptions from this through this market, and will it be a successful listing? Basically, that's the time where the companies and the bankers, no lawyers, but the companies and the bankers will sit together and discuss that this is what I think. This is what we can. What the market is great. Your product would be accepted and the sentiments are great. You should surely go ahead and do the IPO. This is the right time. They'll be given a timeline, say this time to this time. This is the perfect margin where the investors are looking to invest in a company like yours, and the IPO will be good.
But
So
wouldn't
that
this kind of be determined very much in the beginning before even the kickoff takes place? Like,
So that point of time, it is a preliminary discussion. So basically, you will say, okay, the market is great. Let's go ahead, and I want to do a public issuance. That time, the strategy would be, of course, if the market is good or not. But it is just like, okay, let's go ahead with solving this SEBI approval first. It's very important to get SEBI approval first, and it takes a lot of time. You will take, say, 1.5, 2 months. If it's an aggressive company, 1 month. But if it's a good decent company, in 2 3 months you'll take to vet the doc to create to draft a DRHP. then it will take 1.5 to 2 months to get an approval from SEBI. So it's a 5 months process. So it would be difficult for a banker to exactly put a timeline. This is a time when you should go for the
Okay.
uh, issue,
Okay.
but they will have a rough estimate. That's why they're going ahead.
Okay.
But
Okay.
to go or no, it's if it's a go or a no go will be decided after the DRHP is approved by the
Okay.
by SEBI.
Okay.
So then you go, and if it's a conducive market, you'll go ahead and file your red herring prospectus with ROC, and T plus 6 is the date. That is from the date of filing the RHP, your issue will be opening and closing within a certain timeline. And your issue should be open for 3 days, uh, and can be given, the quips can be given a day before. The anchor investors can be given a day before. So 4 days for anchor investors and 3 days for other investors. So depending on the demand, people will subscribe to your IPO, and if it's a success, then if everybody likes it, then you'll be subscribed multiple times, and if it's there, it can be subscribed 90% as well. It depends on the market, and the banker's job is here to ensure that everything is good and they are subscribing properly. So that is fine. That is a very transactional kind of, we as lawyers don't have any say in that. So once the okay, so sorry, one thing I forgot is when a DRHP is filed, there will be certain ads which have to be advertised by the company. So sorry, when the RHP is filed, this is the issue opening ad, the issue closing ad. When does the issue open? These are all statutory ads. I'll call it stat ads. It's according to ICDR, and this is the only place where you can advertise your IPO in hoardings in national newspapers, English, Hindi, and your regional language. If it's Maharashtra, then Marathi national newspaper is required. If it's Gujarat, then Gujarati national newspaper is required. So that is how advertisements work on the RHP stage. On the DRHP stage, you'll have to give one more ad, which is saying that you have filed a DRHP, and the details of this ad, the contents of this ad is not according to our whims and fancies. It is according to the SEBI ICDR regulations. There are schedules which very well stipulate what should be the content of these ads. So please follow that again. Your counsel, your seniors would help you very well in that. Not to worry about it. So moving ahead, once the IPO is subscribed to, the basis of allotment happens. Basically, what is the basis of allotment is that it's again the banker's job, who gets what. If it's an oversubscription, what is how much allotment is happening. Basically, what is the basis of allotment of shares to the bidders. That is a banker's job. We lawyers would not be much of use in that case. But once the basis of allotment happens, as soon as you file the RHP, you start uh, revising the RHP to a prospectus, an offer document, a prospect. That is the final one. It is a book. It's not an invitation to offer. It is a book containing all the details which happened, all the subscriptions, allotments which have taken place. So the details of allotment will be given by the bankers. You don't have to worry about it. But from and there should be no changes in the diligence part from the RHP to prospectus stage. It should not change. There can't be any updates happening to the RHP. Whatever there is RHP, it will be changed to P. That's it. Like if it says this red herring prospectus, it will start saying this prospectus. The only changes will be the technical changes, which are basis of allotment, and RHP to prospectus, and any other dates, past tense, present tense. Say all these things are a part of it. So it says it will be filed later. It should say that it is filed now. The date has to be revised. So all these are technical. They're not diligence based, but the companies constantly do it. There's less work, and it will be excitement because you guys are almost done with the deal. So that is the last part, and then there will be a listing ceremony. There will be a date decided. It will be a part of the
Yeah.
prospectus. There will be a listing ceremony where you will decide the designated stock exchange. Now, the designated stock exchange would be NSE or BSE. It depends on the company. So if it's BSE, if it's NSE, both are in BKC, Bombay. Considering it's done by the board. So then you will be invited. If you're lucky, you'll be invited for the listing ceremony where there will be a listing gong. There will be a big screen,
Yeah.
and at I think at 9:30, new companies get listed. 9:15 the stock markets start, but I think 9:30 the new company, the 10 o'clock I think the new companies get listed. So if it's a good subscription, you'll be happy to see green figures. If it's a bad subscription, it will end up being a bit embarrassing. But yeah, that is how you end up, and that is the end of the transaction, a typical IPO, I would say.
Yeah, so then you have either your MD or the chairman, or they actually hit the gong and your trading starts
Yeah, yeah, yeah.
on the script. So
It's actually the whole family usually, the family, the shareholders who are doing it. It's a company's side, but it's a big thing for them, and it's a relief for us lawyers because we are relieved of our duties, and you usually get appreciations then that okay, Cam did a great job or Sam did a great job or whatever firm did a great job. So you'll be happy for a short while before you get dragged
Chaitanya, I
into
have a
some other.
question.
Yeah, yeah, go ahead.
Could you please throw some light on the underwriters?
Okay, so what do you want to understand in terms of the underwriter, Abhishek?
So I have seen a few agreements where some banks or I don't know some entities take jobs as underwriters, and
So basically,
they're
I'll explain.
really okay. Okay, yeah, please.
Yeah, for everybody's sake, I'll explain what an underwriting is. Usually, the bankers to the council will have their underwriters, who will be the underwriters to the transaction as well. Now, underwriting is of two types. One is soft underwriting. Second is hard underwriting. Now, hard underwriting is basically a situation where I'm a banker, say I am Axis Capital Limited, I'm an underwriter. I'll be like, okay, sir, if the issue is not fully subscribed, I will underwrite the remaining shares which have not been subscribed, or my affiliates will do it. That's in hard underwriting where you will guarantee that I will completely underwrite it, and you'll have to do it by all legal means. That doesn't work in India. It's only soft underwriting. Soft underwriting is where you'll be endeavoring to underwrite your shares which are not subscribed. So underwriting, there is an underwriting agreement which happens after the DRHP is filed. Before the DRHP file, there's one more agreement between the bankers and the company, which is the issue agreement. The issue agreement is basically the agreement for the proposed issue. The underwriting agreement is the agreement for underwriting the issue which is happening for sure. Underwriting agreement is a crucial agreement where each and every responsibilities of all the underwriters are clearly laid out. This is their responsibility. They are endeavoring to underwrite to the issue. This it gets invoked when there's undersubscription. But there are, these guys have the bankers are very smart. These guys have soft books prepared. They know who are investing, and it's as if they're prepared. Like they do a very good job in subscribing to the issue. So that is the somewhat what underwriting means. So there are, okay, thank you for raising that issue. There are certain agreements which have to be uh, executed at different stages. This includes the issue agreement before the DRHP. Then there are certain other agreements which happen before the DRHP is filed with SEBI, and there are certain agreements which happen after the DRHP is filed. That is the underwriting agreement and the other forms of agreement. So yeah, agreements come in hand. There are different kinds of agreements, but yeah, that's all about it.
in view of it being only soft underwriting, like there are chances that issues could fail, right?
There are chances. I think there's one IPO which happened, say, 2 months ago. I think 1 month ago when COVID.
HDFC, I think.
No, no, when COVID had just started, when SBI card started, there's one IPO which got undersubscribed. Then you get the time to extend your issue. So your issue will be extended in terms of the ICDR. You get a chance to extend your issue. Try to subscribe. But honestly, I haven't worked. I haven't been a part of a situation where there has been undersubscription, luckily, because it's a big turnoff for us lawyers. We do put in a lot of efforts. I would like to see the stock opening in green rather than red, because that's the only exciting part. We can't invest in it because we're bound by insider trading regulations, publicity guidelines to be precise. So the only part we can be really, really happy would be good appreciations, a great drafting, organized DRHP, RHP prospectus, and the stocks opening in green. So touch wood, I haven't been a part of undersubscription yet, luckily. So I have less experience in that.
Good. There was a fantastic summary of the whole process, Chaitanya. I think it explained to people exactly how the things fall into place. Now, I think we have a lot of, role and career related questions here, which we can, deal with a little bit. So in the beginning, we had this kind of questions that law firm is one part of it, but if you are the in-house legal counsel of the company who is going for an IPO, or if you are the in-house legal counsel for the book running lead manager, then what's the kind of scope or career areas that you have in this regard? So, like if
So
you are
yeah.
in-house legal counsel, let's say one of the lead managers, then how would things work out for you? How would you be involved?
So, I'm just to clarify, in-house legal counsel from the of the bank BRLMs, right? That's what you were asking.
Yeah, the lead manager basically.
Okay. So, as an in-house legal counsel, it's kind of a pressure job internally, but it's a fun job externally. You will end up avoiding the diligence part of it because you will be coordinating with the legal counsels. You will be tackling their answers, and diligence will be skipped off. Rather than you doing diligence, you can ask that question कि boss diligence हो गया है क्या कितना time लगेगा ऐसा थोड़ी ना होता है. That is the only the best part of being a legal counsel like for a banker like internally. But from other angle, you'll have to rush a lot because then you are the junior who will be running around to file the DRH with SEBI before six
Yeah,
o'clock. But now
yeah.
it's e-filing, you won't care much. But I mean, you will end up doing the physical filing eventually. But you can do the e-filing, but it's a big job because the DRHP is a complex document which is running into 600 pages. You will be the guy who will be printing it, running it, submitting it to SEBI. You'll be the guy who will try to upload it at midnight on the SEBI's website because it's e-filing now and it won't get uploaded. You'll be the guy who will be calling up the council saying कि कम वाला देना, compressed file देना, ये क्यों हो रहा है? अरे इसमें लोगो खराब हो गया, क्या कर रहे हो तुम? So it will be a lot of pressure
Midnight
job.
runs happen for all the lawyers. Chaitanya, it's not like
The only thing
on
you'll
all the
avoid,
sides midnight runs happen.
the only thing you'll avoid is the diligence, but there will be a lot of responsibilities as a banker's in-house as well.
Yeah, right. Great. So other questions which are more related to career is if you're looking actually to get into the capital markets team of a law firm,
Yeah.
how do you start off? What kind of preparations do you do? I think that is one question
So
many
the
people are looking for.
first and foremost thing is like during your time as a student, you if you are thinking of getting into securities law, because as a student I'll tell you what I learned in GNLU. We don't they don't teach you capital markets in your law firms in your law school. Sorry. Yeah, it is only securities law where you'll talk about Harshit Mehta scam or any other big ticket items. What is securities? How do you define it? Give a case study, and it's not very practical. But if you're thinking of aspiring to be a capital markets lawyer, you have to do one thing is intern at a capital markets team at any law firm. Understand what you're doing. Uh, if you get a chance to intern at a law firm under the capital markets team, ensure that you approach your immediate uh, junior and try to take up a lot of diligence work from him, because when you are sitting and interview you are getting interviewed for a capital markets associate, they will ask you what you've done, and they will be very impressed if you've done diligence before. So if you say you have done litigation summaries before in this some of the deals, I'm sorry it's confidential, if you've done capital structure before, they'll be thoroughly impressed. So from that angle, if you're interning, you ensure that you intern at a capital under a capital markets team, and then you get good exposure as a capital markets intern. If you don't get a chance to intern in law firms where there are capital markets related work, there is then you should do one thing, and still you're aspiring to be a capital markets lawyer, then you should do one thing is that understand the basic of issuances. What is a public issue? Just simply Google it. They won't expect you to give a rocket science type answer. They won't expect you to say what is a DRHP, what is the difference, nothing. They won't be technical. They'll understand that okay, your CV doesn't contain prior capital market experience, but they'll also understand that okay, you're interested in being a capital market lawyer, you're aspiring to be one. So you should understand the basics of public issuances. What is a quip? What is a public issue? What is an IPO? Deal teams of an IPO. Everything is available. Basics are available on online, and you can
Or
surely
you
go.
can go for the securities laws and capital markets course of LawSikho, guys.
Yeah,
So that's something you can have a look at. Because see, like I
correct.
always say, things have to be structured. And as Chaitanya was putting it, you get things in a way as the law is it is. Like you will always have ICDR taught in the likes of, say, when you are doing CA or CS, you'll be briefed about what ICDR is, what LODR is, but you are not going to get to come to know exactly what the kind of work that's going to be done. How do you deploy? How do you put those things into practice? Okay, how do you apply those regulations? That is something that is
Which you
not
learn.
really academically taught, right?
Correct,
So
correct,
interning at something is one part of it. Structured learning, okay, or having a simulated learning is another part of it, and that's what like LawSikho does. So you can definitely have a look at this course. You can let me
correct.
know if you have any questions, and reach out to us after
And
this.
I've been
Yeah,
a
but
part of this
yeah, Chaitanya.
module by I've been a part of this module which is launched by LawSikho, so I am a part of
Yeah,
it.
Chaitanya is our mentor on this, together with other people also who are in the capital markets teams of, let's say, Jay Sagar associates, even Sam. So we have people who share insights with us on this. So when we develop this, it comes from the insights of people like Chaitanya. That's how we can bring what exactly is the work that's done by the people in this field. Right?
Yeah, yeah. So, uh,
We have many questions again which are related
sure, sure.
to career and
So yeah, so the second was if you haven't interned in a capital, that was where I was. Third was that if you have never interned at all in any law firm, and if you still are aspiring to be a capital markets lawyer, you should be honest again, saying that okay, I have no prior experience in public issuances, I have no prior experience as an intern, but I want to be a part of it. I want to try it, and you have to be honest. Of course, you need to know the basics again, public issue, what is all those things, shares and all. So once you do that from a corporate angle, you can try. I wish you good luck for it.
right. Someone has queried about prospects of an LLM in capital markets from NISM, or for that matter, the postgraduate diploma
So
also. So
it's
what are the
I'm
prospects of that?
I'm happy to state that the capital market lawyers have 100% job security. There are certain, then this is a niche practice, and even in terms of uh, uh, an LLM, if you, for example, there are international law firms like Allen and Overy, Sidley, then Linklaters, all have their own Indian legs of capital markets team. So everybody, see, as I told you, all these major deals, there are an international deal. So there will be an international legal counsel to every deal, and they have an Indian leg to it. So I've worked in all transactions. I've worked with international legal counsels. So to answer your question, if you do an LLM from an university like a Singapore-based university, then your chances of getting a job in an international law firm would be higher, Asian market. If you are graduating from a UK-based university, or you're in a UK London-based university, then your chances of ending up becoming a lawyer in Asian market is way higher. And you can also think about joining the European law firms as well. But if you are graduating from a US based university and you end up, or you work hard and you're a stud, that you end up graduating from NYU and get a, degree, clear the bar of New York, then there is no limit to it. You will get a number of offers from different law firms. But I suggest you gain 3-4 years of experience in India, then you go for an LLM. It's logical because 23 to 26 is the age where you just graduated from your different colleges, and you'll have this sudden urge to earn money and be responsible. At the same time, you will also would want to gain experience. This is a time when you slog a lot. This is a time when you learn you would want to learn everything, and this is a time when it's the most crucial year for you guys when you're graduating. So these are the slogging years, and I would suggest you start in India, work for 3 years, then venture into masters, and then think about taking an international job. It's up to me. That was my plan before I started my own business, but that was my initial plan, I would say.
Right. There are also questions in relation to comparison, like do you have lesser scope in capital markets compared to other things like, let's say, M&A or litigation, other roles which are typical for lawyers. So is there a lower scope in capital markets and there's more competition, or
See,
how does that work
yeah,
out?
I was a part of, as you all would know now, I worked in CAM. CAM has a rotation policy. So as a fresher getting a PPO your from your university, you have three rotations to do, and you can choose the department you want to work in. So either it be corporate, it be real estate, it be litigation, as you said, or it will be capital markets. The first thing I took was capital markets because I had an interest in securities law while I was in GNLU. So I voluntarily took capital markets. The second I took corporate, and it I didn't fit in well. So I again went back to capital markets in the third rotation, and then I ended up in capital markets forever. So from my experience, what I have seen is that as a 23-year-old or as a fresher, you would want to learn everything at one go. But if you are a part of M&A, you learn only the corporate part of it. You learn the secretarial part of it. You learn the capital structure part of it. If you are a part of litigation, you learn the writ petition, PIL part of it. Only litigation, very very particular, very niche to litigation. If you are a part of, if you're an economics lawyer, then again economics. If you're a real estate lawyer, you only work on litigation or real estate diligence or real estate opinions, reports, all. But if you're a capital market lawyer, there is one chapter which talks about the capital structure of the company, where you'll have a chance to learn the capital structure of the company. You'll have a chance to vet documents. You have the chance to diligence the share transfer forms, the demat forms, the board resolutions, the shareholders resolution, everything which happens in corporate. Capital structure and history chapter will take care of the corporate part of your diligence. So you learn everything about the corporate part of the company, like the secretarial part of the company. Then you go to approvals. You learn everything about the company, the approvals which are applicable to the company, the diligence of these approvals. Now, as if you end up joining the employment team of your law firm, you will start vetting the employment agreements. Then you will go through the Labor Act and all those cumbersome stuff. Here, everything happens at one go. You'll have to go through EPF. You'll have to go through shops and establishments. You'll have to go through the sector-specific approvals, like for real estate, it's RERA or occupancy certificates, way other stuff, other sectoral specific approvals which are required. You'll go through the other regulations, which are labor intensive regulations like CLRA, which is very, very cumbersome, and there's a lot to learn. You'll go through that as well in an IPO. So that is taken care of. Now, litigation, you'll end up summarizing all kinds of litigation. You'll understand what's a PIL, you'll understand what comes first, what are the series of events. You'll be thrown with a lot of documents. You'll understand every step of litigation. You'll end up summarizing it. That is called as a synopsis in under litigation language. So you'll end up summarizing it in a very small manner, a very crisp manner of what happened, which will be perfect for the investors to learn. So you'll handle the litigation diligence very well as well. Then comes the regulatory policies applicable to the company. What are the regulations applicable to company? If it's a banking company which is going for an IPO, then there are a lot of regulations
Yeah,
applicable to company.
yeah.
So you'll
I
end up
think
reading
the
everything.
question is more from the perspective of how difficult something is to get into. So, like, is it a relatively difficult area to get into as someone who's a beginner compared to the other areas?
So what I've seen in the past is it's an easy area to get into, but there are less people to get into because they are
Exactly.
scared of the
So
diligence
the
which they're doing.
competition
So
comes
the
down.
way I wanted to put is that this is what you're learning. That's why you should join. So that's a different angle that, okay, people will rather think of it from an angle where they want to get into it rather than they questioning whether should I get into it or not. So you learn a lot during as a capital markets lawyer. So you see right now under COVID, the IPOs are less. I think the last IPO which happened was of SBI cards. After that, there are, I think I haven't followed much, but there will be DRHP getting filed left, right, and center. There are capital market lawyers working around certain offer documents right now. Maybe I'm pretty sure about it, but the market is bad. The financial institutional investors are bailing out. They have come back again. The market is again recovering slowly. It's the right time to invest, basically. But yeah, so after COVID is gone and everything is normal, I personally, it's just my view, but I personally believe there will be a lot of work for capital market law. There will be a lot of transactions coming in. Right now, Reliance is going for a bond issuance of 10 billion or something. It is on news. It is in news right now. So people won't stop raising money. Companies won't stop raising money. They want money, and with less business happening, I think they will go for further issuances for sure. So there will be a lot of work coming up, exciting work, different kinds of work. So it's the right time. Firms will recruit capital market lawyers, and it's the right time for you guys to join. Whoever is graduating in this year as well.
Lending will start becoming difficult. So where else will you go for, like, if you have funding requirements, where else would you go? Like PEVCs again, very selective.
So PVC again, it's a different ball game after all. But what I'm reading and what I'm seeing right now is people would go back. They won't get out of the Indian market. There are companies who are interested in the Indian market, and IPOs. Whatever companies are going for an IPO, they are solid companies. And
Yeah.
from a diligence angle, everybody is vetting it properly, and from the financial angle, they are solid companies. So there are quality investors, I would say, interested in IPOs, and 65% is for the quality investors. The rest is retail and HNIs, but the major chunk is picked up by quality investors. So I don't see a problem. I see it's always positive. Nobody would stop investing in India. So
Yeah, that will definitely move on. So there's a question from Abhinav here. Name some tier two, three law firms in the capital market. I think you already did that, and
yeah,
there's an answer that's given anyway here.
so it's
So Indus Law,
Indus.
the CAP,
Tier
SAM, and Trilegal are tier one
even
firms
SNR.
anyway.
SNR is way tier one then.
Yeah,
But tier two would be Indus, DSK Legal, Juris Corp, Vadia Gandhi, uh, yeah, maybe JSA. JSA is also tier two. JSA
yeah.
might call it tier one, but I call them tier two, so I'm not sure about it. You can keep it wherever you want to. But yeah, that is all about it.
So Sarthak has a question here. What's the role of CACS in the what is the question? Role of CACS in the process. Can any of the duty be performed by any other professional?
So as I said, auditor's certificate, auditor's deliverables, which are a, a quintessential item in IPO, is done by a statutory auditor, a certified CA. So their role is very, very
I think the
important.
volume is a little bit low, Chaitanya, if you could
Sorry,
hold the
sorry.
mic.
Yeah. Can you hear me now properly?
Yeah, yeah, yeah.
So, as I said, that auditor deliverables, which are a quintessential item in an IPO, is done by a statutory auditor to the company who's a chartered accountant, a practicing chartered accountant. So that's the role of a CA. He'll be issuing certain certificates without which the IPO cannot happen or the deal cannot happen. So that is the role of a CA. Now, CS usually becomes the compliance officer of the IPO. So if you look at
Yeah,
any top page at the front page of a document, you'll see the name of the CS. It says company secretary and compliance officer. So the
yeah.
CS role is very, very, very important. And usually the CS becomes the compliance officer, and he or she takes up a major role. So both are very important. Anyway, under Companies Act, CS is a must now. So there would be a CS nonetheless. So uh, I don't see a they
See,
have to be a
even CAs from the inside, where you are actually working in the finance and accounts departments of companies at the time of IPO, again, like it's heightened activity everywhere inside the company. If you are the company secretary of the company that's going for an IPO, if you are inside the finance department of a company that's going for an IPO,
yeah,
or
yeah.
it will be everywhere a heightened activity. So
It won't. The
definitely, like, you have roles to play.
life in a public issuance is not possible without a lawyer and a set of professionals like CACS. So we all are a part of it nonetheless.
So someone has a query here on agreement drafting, like underwriting agreement, share transfer agreements, depository agreements,
So
agreements with a BRLM. Who drafts this?
so I'll tell you, share transfer agreements we don't draft it. So
No, no, agreement with the RTA.
RTA is done by the company itself. Issue agreement and underwriting agreement is done by the bankers council, and the company's council will be commenting on it. And every set of agreements. So say it's Cam, Sam, or Khetan, every law firm has its own draft of underwriting or issue agreement. It's very, very technical. And as freshers, we won't be a part of it, very honestly, because there are reps and warranties being given. There are usually biggest fights happening under these agreements, and they're very crucial to the transaction. It will be either handled at the partner level or the principal associate level, not even the SA. So you guys will have a lot of time to go there, I would say. But if at all you get the chance, then you're really lucky because it's a non-diligence kind of a work, and you should grab the opportunity. When you get it, you quickly go to your send, ask your other colleagues, ask for the previous agreements which you might have executed in different deals. Understand what kinds of reps you give, the way you represent your company or the bankers, whatever the case is, and stick to that point. Because there's a point which comes that no, we have to do it. So if it's A and B lawyers fighting against each other for a certain representation, then it's always a very, it's not for it to be a win-win situation. You'll have to give up a few reps, and revise a few. So it's a big task. It depends. It's the most negotiable agreement of any transaction, and luckily or fortunately or unfortunately, I haven't been a part of it, but I've attended trainings, calls where my senior is negotiating with the other counsel, and I was just sitting there and understanding what the hell is happening. So yeah, it's a very negotiated one. So I will leave it up to the. Uh, so yeah, why did you leave Cam? Stressful environment.
That's a very frank question.
So the way I am talking about capital markets, you guys would have understood that I am really fond of capital markets, and the way I have drafted one chapter for Komal, she would also understand that I am passionate about it. Now, I'll be honest. I am from Gujarat. I am an Andhra. I am an Andhraite, but I'm brought up in Gujarat, and I always wanted to do my own business. So at the age of 26, I felt I'm married. I have no responsibilities. I have zero cost of living in Ahmedabad. Why not try business? That's why I quit CAM to do my own, to become an entrepreneur. So it's, of course, it's stressful, but it has to be stressful. It has to be stressful. You have to learn a lot. This is a time when you slog, you sleep less. Now there have been times where I haven't gone home for 3 days when I was in camp. There have been times when I used to go reach by 7 o'clock in the morning and get up and get ready by 9 o'clock and go back. But it's for a good cause. You learn a lot. You will end up swearing a lot. You'll end up losing your patience, but you will learn a lot, and this is the time to learn. There can't be any work life balance, I would say. To For you to be a great capital markets lawyer, worry less about the work life balance, more about the work which you would want to do. You'll have to learn a lot. You have to create a base, and this is a perfect, you create your own base. You learn, you do it on your own. So
I'm confused between PEVC and capital markets. What should I choose?
see, right now,
So
uh,
you can't choose, the work will choose you, Ishwar. So
I have a very close friend who's a PVC lawyer. She's doing very well, and she started with Indus Law Bangalore. So I mean, everything is the same. Uh, as far as I know, PVC is a bubble which will go on for 15, 20 years more. So you have great scope there. You will be a part of startups. Like I have this friend I'm talking about. She has worked with Walmart. She's worked with Dunzo of Bangalore. Exciting startups like nothing else and nothing else. That's the name right now. But it has worked with startups. While as a capital markets, I've worked with companies like Loda, Polycab, Spandana, and I've seen other companies, big companies. So right now, as an entrepreneur, I'm looking for PVC. But as a lawyer, I would be interested as a capital market lawyer. But of course, you can go for PVC. I know my friend is happy in PVC. I'm proud of her as well. So I think you can go for anything you want.
see, if you are in love with that area, then it doesn't look any like, you don't see anything at. This is what happens, and like at that point of time when you are going through a transaction, if you it happens to everybody who's involved,
Yeah, it
right?
depends on
So
what you want. I mean, it happens by
yeah,
accident. it happens by accident that you end up landing in a team which
We have a
uh,
lot of career related questions. The stream is not ending at all. Like there is a question on NLU tag. Guys, you can have a look at, where you can have and non-NLU lawyers do stuff much better. Like Ramanuj has written a whole book on that. You can have a look at that. And there are lots of questions that are related to scope for CAs, CS plus BA, LLB. What will be the impact of COVID-19? I think already Chaitanya said that it is expected to increase later, like once you have
see
a lockdown lifted.
sorry to interrupt, Komal. On CS plus BA LLB question, it's a
Huh.
great combination. You are a star if you already passed CS. I tried, I couldn't pass because I was getting bored of it and I already had a job and I was working in camp, so I couldn't pass CS. But if you have a CS, then it would be very beneficial for you from a secretarial angle, but it doesn't add to the value. It doesn't add to your compensation. It does add to the value. Sorry, you won't get compensated for that. You won't be, uh, of course, in a job scenario where you are a CS, you have a CS degree as well as you're a lawyer graduate, then you can get an upper hand to get recruited quickly as compared to the other non-CS. But from a compensation angle, you don't get much. Like it's the same. There's no, like, you won't get more money if you are a CS.
Okay, I guess there's another question. I think we'll deal with this the last and we'll call it day. Any career related questions that you guys have and you want to deal with, like we have, I will leave my number here for you guys and you can reach out to us and we can deal with that individually. The last question that I'm going to take here is how important is litigation in capital markets? So, what
Uh,
kind of litigation can crop up in capital markets?
that's like litigation was my 70% job in camp. When I joined, I was thrown into the litigation part. Then in my last years, I have done a very big deal, which was very litigation heavy. So litigation is a very crucial part. Um, it's just you you have to. It's just as an investor, imagine your father investing in the issuance. Okay, I mean, I don't know if that's allowed. It's insider trading. I'm just asking. Imagine your relative investing in the IPO which you're working on. That's how you should be informative. You should think that,
Absolutely.
okay, I should give a fair idea to the investors. They should take an informed decision. They are investing on my basis. That's how crucial the disclosure are. So you will hear it when you're training as well, but diligence is a cumbersome part, but it's a very crucial part of any transaction, and you guys are drafting it. You'll feel really happy when you see your disclosures in the DRHP, which is publicly available and everybody is reading it, and you can proudly say that, it's you have done, you have drafted this. This is how it's going in. I look at it that way. Uh, so litigation is very crucial. It has to state everything from A to Z: who filed the petition, against whom, what is the amount involved, what is the brief facts of the case, what is the latest situation, the latest situation in the matter, and that the matter is currently pending. Now, just remember, everything is outstanding litigation. ICDR doesn't tell you to disclose closed litigations, except for in certain areas. If it's regulatory matters, then you'll have to end up. But I'm talking from a civil criminal angle. If it's only outstanding, you'll have to disclose. So the end part is always the matter is currently pending. The amount involved is very crucial. In criminal, it won't be quantifiable, so you don't have to write it. It's fine. People understand, SEBI understands, everybody understands. But it's very simple. You have to include everything that a person, after reading it, understand. Okay, this case is okay. I got the point. I got the facts. I got who's the person filing it. Because at the end, you'll end up receiving complaints from the litigants, and it would be a bit of a task.
Yeah, yeah. Sandeep, okay, we can deal with your question last. Why don't you unmute yourself and ask the question, and then we'll call it a day.
Hello. Yeah, thank you so much, ma'am. What I wish to ask is, will doing CFA add value? Is it better than CS or CA, and will it give an edge, and will it add value both the knowledge wise as well as the compensation wise? Thank you.
Uh, See, from CFA angle, sorry, I have very less idea about it, Sandeep. Komal, if you can take this, it adds a lot of value. It adds a lot of respect from my side personally. If you've done CFA, CAs as well, you're a lawyer. I'll give you a lot of respect. I really, I have no idea from the job angle. I'm really sorry about it. It's just I haven't come across such an issue.
Yeah, I think it comes on to the so you're looking at CFA and LLB as a combination, or so it can
Yes,
help you
madam.
understand a bit on the securities market better. But again, like how Chaitanya was saying, that it's not going to, change your work as a lawyer if your actually ultimate destination is to get to work into a law firm, right? Then that's not going to change things. It might change things for you if you are actually on the in-house side of a company that is going for an IPO, because you can maybe be capable to take care of dual requirements of finance and, let's say, secretarial and legal. To an extent you can have people reporting to you, but if your actually destination is to go get into a law firm, then I'm not sure how much CFA will help to. So it depends on what your destination is and where you want to land up at the end.
Uh, Madam, can I just quickly add one small thing? What if my desire is to be a lawyer who has an independent practice in corporate law, so far as white collar crimes and minority stakeholder violation of the rights of the minority stakeholders goes? Will that combination be effective then?
Yeah, but it is so this is a discussion that is very different from what we are doing right now on capital markets. So white collar crimes is a completely different area to look into or get into, right? And you may look into naturally where you have a better understanding of how securities transactions work or how financial crimes work. It will add up to your knowledge of even the legal side of it. If you have a combination of both, it will help you in that. But capital markets is a different area altogether.
Okay,
White
thank
collar
you, madam.
crimes is a different area altogether. Right? In white collar crimes, you might be thinking more from the intermediaries point of sight, maybe where there are broking related crimes or something like that, or unfair
True,
trade
true, madam.
practices. Anand was here some time back, like he can answer this question better for you.
True, true,
So
true, madam.
Anand is a faculty in our securities laws course, and he is, he has a very good idea of how intermediary transactions work. Okay, so this may be more relevant from that perspective rather than from the perspective of a company hitting the capital market.
Okay, madam. Yeah, thank you, madam. Thank you.
Okay, I think we'll end the session now, guys. It was very interactive, and like I said, any further questions that you guys have, you can always reach out to me. I've left my number. I'll do that once again, and we'll call it a day.
Okay, thank you, Komal. Thank you.
Thank you so much. Bye bye, everyone.
Thank you.